want to turn it over to our wonderful host for today from Trident Management. I think he's actually the founder as well. We have the big cheese with us today. This is Jason Schoenholz. Jason, how you doing, my man?
Doing wonderful. Thank you. And thank you guys for doing this for us. I appreciate it. So, for those of you who don't know me, I am Jason Schoenholtz. Yes, I am the CEO and one of the co-founders of Trident Management. Been in the association industry a mere 25 years. So, brand new here, still learning. Thank God Alan's going to teach us all. Um, but no, in all seriousness, I've been doing this for 25 years. It's all day, every day we do. We are located in Southeast Florida, so we're in the Miami, Broward, West Palm, a little bit in the Keys, and then we have a small outpost up in the northwest corner of the state, so up in the Pensacola Panhandle area. So serving condos, HOAs, all those good things, but more importantly, serving constituents like you guys. Super active as a CAI advocate in our Florida Legislative Alliance,
Right.
spending time in Tallahassee, working with actually with Michael in your office and Lisa in your office, doing advocacy and looking out for our condo and HOA owners. So a lot of what Alan's going to talk about today, I'm not going to say I wrote it or was responsible for it, but I definitely threw a word or a comma or a comment at least that was either ignored or taken to heart. So.
Well,
Uh,
probably a comment too, asking them to pause and reflect on the legislation they're about to pass, right?
That we actually got this year. I don't know that that was on us because they had their own internal strife, but we definitely got a pause this year, so that we're pretty happy for.
And Jason, one quick question before we get to Alan. You're expanding. Yeah, you're up in the Panhandle. Now, let's say, we have a lot of folks here today. Maybe they're happy with their management company. Maybe they're shopping. But if they're happy with their management company, can you also act as a third arm, as maybe a consultant for a project they might have going on, and they want alternative advice or input on what they can do? Is that something you can help
Absolutely.
with?
Yeah, so absolutely. First of all, I think this is an amazing industry. It's given me a wonderful business, and I get to do a lot of things, so I get to give back, right? If you have a question, a comment, you need a second opinion, we're here for that. We also have a huge project coordination division where we handle projects for communities that are going through what they're doing, whether it's governance issues or going through literally projects, concrete restoration, things like that. So we're here to help. I hope you're happy with your management company. There are a ton of great ones out there.
Right.
Please keep using them if you are. If you're not and you have a question or you're thinking about it, we've been self-managed and maybe it's time things are changing, that there's a lot going on. Definitely talk to us and we'll see if we're the right fit for each other.
Sounds great. Thank you, my man. Thanks for collaborating with us today. We appreciate you as well. So let's turn it over now to one of the very few board certified specialists in condo and plan development law in the entire state of Florida. This is Alan Schwartz out of our Central Florida location. Alan,
All
welcome
right.
back.
Thank you. It's been a long time since I taught a webinar. I think it's about 2 hours now.
Around
Uh,
90
so
minutes.
it's
Yeah.
it's good to be back. We did have an HOA board certification class this morning, but Jason, Trident, we appreciate the opportunity to come out, provide some education because it's just as important to us as it is to you. I mean, you mentioned Mike Bender, Lisa McGill go out and try and fix the problems that the legislature tends to occasionally create for us. Thankfully, we got a little bit of a respite this year with no real meaningful HOA or condo legislation coming through. But getting into what it is we do as a law firm, K. Bender Rembaum's been in existence since the 90s. We've done nothing, almost nothing, but represent community associations since then. As Jeff mentioned, am board certified in this area of law, along with 8 other attorneys within the firm. One is board certified in construction. So out of the 27, that's a pretty good ratio of, I think, 10 who are board certified in something. And what that means for all practical purposes is that the Florida bar calls us experts in one field of law. For me, for 8 others, that's representing community associations, which is what we do, and it's all we do. Other than I mentioned we do some other things, that's being just a mediator and representing occasionally owners with respect to recalls and election disputes, but we really don't get into the representing the owner on every issue. We try and focus all of our practice on representing Jason, the same types of folks that you work with, which is protecting the board, protecting the association. So again, 27 attorneys effective on Monday. We've got another coming into my office in Winter Springs, 4 offices, mine in Winter Springs, one in Pompano, one in Palm Beach Gardens, and one in Tampa. So anywhere in the state that you're located, we've got you covered. Like Jeff mentioned, if you're happy with your attorney, good for you. I'm not asking you to switch. But if you're not happy, you need a second opinion, you're looking for someone who can work independently on a specific project. Maybe there's a conflict of interest because they represent another association or entity that you're working with. We do come into those situations, and because we don't require an upfront retainer to work with community associations, we don't have annual fees except our special collection retainer program, no monthly minimums. We try to make it easy to work with us. It's just a matter of getting your governing documents, putting them all together, and then we can get started. So, without further ado, I'm going to go ahead and share the slides and we will get started. So, we've got that up and we should be good.
Looks good.
All right, thank you. Let me resize here and we are good to go. All right, so we're going to skip the information about me because if you need to know more, you can just read it or email me. My email is right at the beginning of the slides, but you also have it on your screen if you can see me in person because Jeff was kind enough to put that on my little background. Why are we here? Because the Florida legislature finally acceded to the request that people like Jason and my partners have been asking for a long time. Primarily, it was the requirement that you got to take at least a class as an HOA or condo director so that you have some idea of what you're doing as someone who is volunteering to run a business. Because whether you realize it or not, that's what you're doing as a director of an HOA or a condo. Now, we're here to discuss HOAs in particular, but it's the same thing regardless of which type of community you're running. Now, there is a difference in when and how you need to get these credits. The reason that we're teaching this class is not just to provide education, but also to offer one of the credits, or actually I think it's 2, Jeff, you'll let me know if I'm wrong, I'm sure. But we're offering some of the credits that every HOA director has to get each year on what I call elective classes. It's called continuing education in the statute. And what that entails is if you've got less than 2,500 lots in your community, you got to get 4 hours of classes like this each year. If you've got 2,500 lots or more, you need 8 hours. Now, when that starts and finishes, kind of up to DBPR. They've vacillated a little bit. My understanding is that they're now going with the logical approach of it's from July 1st when the statutes actually came into place 2 years ago through June 30th of the following year that you have to get those 4 or 8 credit hours. So we're just going to leave that behind and get into the material because I could spend 15 minutes on why I think some things just make no sense that the legislature and DBPR have done. We're going to start with member meetings. Now, the annual meeting is really just, hey, we're having our election. It's that simple. That's your regular meeting of the members. It doesn't need to be held at the annual meeting. It usually is, but it needs to be held in conjunction with the annual meeting. I really haven't seen an HOA hold it at any other time. It's going to be, we're having our annual meeting. We don't want to have to schedule another meeting for the election, so we do them both at the same time. Special member meetings are literally any other meeting that your members get to vote. Because that's the difference between a board meeting and a member meeting is who gets to vote. A board meeting, the board gets to vote. The members' input hopefully is factored in, but they don't get to say yes or no on the motion. They don't get to make the motion. That's what happens at a member meeting. A member meeting is the members are voting on something. It's usually going to be either the election, you're going to be voting on amendments to a governing document, or you're going to be voting on something like switching what financial reporting level you want to be at. Or maybe you're filing a lawsuit for $100,000 in damages or more. But most of the decisions that are made are actually made by the board. So we do have special member meetings, which is, again, literally any member meeting other than the annual meeting. And that's going to be held either because the board said, hey, we think we need the members to vote on something, or the members unilaterally came to the board with a petition with either 10% at least of the voting interests, or if the governing documents give a different percentage, that percentage. And that many people within the community, that many members actually signed a document that says, we want a member meeting to vote on this issue. It's not we want a member meeting. It needs to be for a specific purpose. So you need to have an identified purpose for that meeting. And then the board has the obligation to actually call the meeting. The notice, the agenda is all, and we'll get into this, but the notice and agenda is all going to say what the purpose of that meeting is going to be. And again, that's anything other than a regular meeting. Anything other than the annual meeting is a special meeting. Agendas. Every meeting of the board or the members needs to have an agenda, except for the annual meeting. I would recommend, and our firm generally recommends, have an agenda anyway. The purpose of the agenda is to outline what you're actually willing to discuss during that meeting. And I'll clarify in a minute, but the purpose of the agenda is to say we're limiting what we discuss to what's on the agenda. So if all you're going to vote on is the previous member meeting minutes and your election, and you're not touching anything else at the annual meeting, then technically the members don't get to bring up anything else at the annual meeting. So you can conduct your business and get the hell home. That's the goal. Okay. Now, you may still need to count a ton of ballots, but at least you can do your business and be done. So again, you're not required to have a meeting agenda for the annual meeting. I recommend doing it anyway. You are required to have it for any special member meeting and literally any board meeting. So again, just make that your practice. Don't try and remember the exception to the exception to the exception. Have the agenda, move on with your life. Notice requirements. And again, we're still talking about member meetings, not board meetings as of now. All the notices need to provide the date, time, and location of the meeting. Basically, how do people attend this thing that aren't on the board and don't already know when you're having the meeting? That's the purpose. It's to give them the opportunity to show up if they want. The purpose of the agenda is to let them know what you're going to be discussing and let them figure out whether they care or not enough to actually show up. If the bylaws don't clarify how notice is given, the association is going to mail, hand deliver, which I have not seen any community do, but it's still in the statute, or electronically transmit notice, which we'll touch on in a second, to all owners not less than 14 days before the meeting. You need an affidavit that goes in the official records of the association confirming that this was sent out, what addresses it was sent to, and preferably contains a copy of what was actually sent. Now, I mentioned we get to electronic notices in a minute. Here we are. Okay. You cannot just send an email blast and think that's good enough as a notice of a member meeting. You can send an email to people that have opted into receiving notices that way, but you can't just send an email to everyone you have an email for and presume that it's sufficient. If you don't have an opt-in form or an electronic checkbox opt-in from each owner, and when I say owner, I mean each lot. I don't mean, John and Jane own together and you have to have each one sign off. You need to get one from each lot, and anyone you don't have that opt-in form from, you still have to mail out the notice. So understand, the fact that they've agreed to accept these email notices is great for the association. It saves you time, it saves you money and mailing costs and printing costs, but it's not something you get to use unless and until the owner actually opts in to receive notices that way. Now, the notice needs to be mailed or delivered to the address that you have in the official records of the association. That's not necessarily the property. If someone told you, I don't live at the property, here's my mailing address, or I do live at the property, here's my mailing address, or I'm opting in to receiving electronic notices, here's my email address, then it's not just let's mail it to everyone's property address and we're good to go. It's whatever those people designated as the place they want to receive notices, you need to use. Now, it's on them to keep you updated. So if they don't live at the property and they're renting it out and their tenant doesn't give them a copy of the notice that you mailed to the property because they didn't give you a mailing address, that's on them. They didn't get the notice, not your fault, not your problem. But keep in mind, the goal is always to enfranchise, meaning to get as many people that can actually attend the meeting as possible so that they can show up and vote. And hopefully that means you have the best chance of accomplishing whatever the goal of that meeting was. So when you're getting a member vote, you want people to vote. You want them to hopefully show up and take care of your business with you and for you. Okay, electronic notice requirements. We went through most of this. The email addresses and fax numbers provided by members to receive notices that way need to be removed from the official records if the owner gives a different email or fax address. So if someone says, I'm not using that mailing information anymore, the association pulls that mailing address out of the records. Any mailing address that's given to the association for sending notices is an official record and is subject to inspection. So that's when someone sends a records inspection request, you do need to give those mailing addresses out. You can't give email notice or fax notice of a special meeting for recall purposes. That's a meeting of the board. But understand, if you are voting on the recall at a member meeting, that is not something you can use email notices for. So you're still going to mail that notice to the mailing address. And keep in mind, this might be the wrong address because someone may say, I'm giving you my email address. Why do you need my mailing address? Nothing you can do about that. But you're not going to use that email address for mailing a recall meeting notice. I know that's something that I've repeated a couple times. I see people screwing it up very frequently, and it's what ends up getting associations sued because they held the recall meeting but didn't provide notice to the people entitled to it. Broadcast notice, I don't know of anyone still using this. This is when you put it on CCTV. If you're using it, just reach out to your manager or your attorney. Website posting. So effective January 1st of last year, as of this recording, not this year, last year, an HOA with 100 or more lots was required to post the notice and the agenda of each member meeting on the website that they're required to have at least 14 days before the meeting. Now, the good news is people that are freaking out when I mention, oh, you have to have a website, your management portal will almost inevitably serve as that website instead of you having to go out and create a separate one. So don't freak out just because I'm mentioning this 2 years after it went into effect. It's generally, this information goes on your management portal and your manager will be the one that uploads it, takes care of all this, and you get to move on with your day. The notice of each member meeting, and by the way, this is going to be the exact same thing with board meetings, but a different timeline for posting on the website and mailing the notice. That goes on a separate portion of the front page or a separate subpage labeled notices and is conspicuously visible and linked from the homepage, meaning it has to be easy to locate. The association also needs to post any documents that the members are going to vote on. So if you have a member vote on a contract for some reason, a member vote on amendments, any document the members are voting on in a community that needs to have a website needs to be on that website within 7 days before the meeting when it's going to be voted on. Now, I have a lot of people asking me, what do you mean I need to post the amendment before it's voted on? And my response to that is there's nothing in the statute that says yes or no. The safer course of action, the least risky option, because it is a document you're voting on, doesn't say contract to be voted on. It says document in the statute. My perspective is putting it up there is an additional 2-second hassle that avoids the potential of a lawsuit for not posting it. Now, there's also a statute that says there's really no damages when something's not posted to the website. But why would you want to risk having to defend on that basis instead of not having to deal with that lawsuit in the first place? Yes, it's an additional administrative hassle, but it also avoids a lot of heartache down the line. Members have the right to participate in every member meeting and every board meeting except the ones that are closed. This is what I was talking about earlier, where you want to not curtail the behavior of participating in the meeting. You want to encourage participation, but you also want to still be able to run your business, which is the HOA itself. So one of the things that you can do to ensure that you're able to run that business is adopt a policy governing how members are allowed to participate in these meetings. This is included, I think, in the next slide, but we'll get to it in a minute. But owners have the right to attend all member meetings and speak at any meeting with respect to anything that's on the agenda. Now, here's the dangerous part, and anything open for discussion. So if the board starts talking about an issue that's not on the agenda, now you've given every member the right to speak for another 3 minutes on that agenda, that non-agenda item. This is why I'd have an agenda and stick to it at every single meeting that your association runs, whether it's a member meeting or a board meeting, because then you can conduct your business. You're still going to give everyone their 3 minutes allotted, that all the members get their 3 minutes to speak on each agenda item, but you're not going to be stuck dealing with another 3 minutes where you may have 30 people that want to speak You're not dealing with another 3 minutes times 30 for an item that you didn't even put on the agenda, but some director made the error of being willing to discuss during the meeting. So understand, when people bring things up, it's not the board shutting them down if you say, we're not going to address that today, or come see me after the meeting and we'll discuss it. It's the board being able to conduct its business and conduct the members' business, and not sitting here and, I won't say capitulating, but not sitting here and giving everyone the opportunity to run ramshot over your meeting. Because that's what it is. It's a business meeting and needs to be run that way. The association, like I said, can adopt written rules governing the frequency, duration, and other manner of owner statements. You can say the members are allowed to speak only at this time. You can require them to sign up in advance to speak. You can tell, basically say, here's how we're going to run our meetings. There are limitations. Again, you have to give at least 3 minutes for each agenda item, but you can say no member can cede their time to any other member, so that you're not sitting here with John filibustering the meeting and speaking for 45 minutes on something that's not even on the agenda because one of the directors decided to open the door to it. Okay, you can limit the member speech to what is reasonable, and the time that they speak and the duration, etc. It needs to be held, if someone requests it because they have a disability, at a location that's physically accessible to someone who has a handicap and needs and requests that accommodation. We have an entire class on accommodation, so I'm not going to go into detail about the Fair Housing Act right now, but that's what we're talking about here in this first to last bullet point. And the other thing to keep in mind, another rule you can adopt: owners are allowed to tape record or videotape member meetings. You can tell people you're not allowed to walk up to the person that's speaking and say, I'm recording you. I'm recording. Well, you can't see my phone, but you can't walk up, scream in their face and say, you're being recorded right now. You can require that people set up a recording device, whether that's a video camera, audio recorder, or frankly, a cell phone on a stand. And you can require that it not be in the way of anyone else's ability to perceive and participate in what's going on in the meeting. So again, it's just a policy that your attorney should be able to prepare for you, usually an hour and a half to 2 hours of attorney's fees, but it can avoid a lot of headaches, including people that just frankly won't shut the heck up in the middle of a meeting when it's not their turn to speak. Now, a quorum of a meeting of the members is 30% of the total voting interest of the association, unless a lower number is provided by the bylaws. Now, keep in mind, this means that if you have a 50% or a majority of the members that's listed as a quorum in your bylaws, sorry, but it's only, well, you're welcome, but it's only 30% of the members that are required. Now, the purpose of a quorum is to say whether you can hold a meeting or not. So if only 30% of your members show up and your bylaws say you need a majority, well, the statute says you can hold your meeting anyway. So be aware of this statute. Decisions are generally, unless there's something specifically stated otherwise in your governing documents or the statutes, it's a majority of the people that actually show up at a meeting where a quorum is attained. So if you're saying a quorum is 30%, then 15% plus 1 could be the voting percentage that's needed to pass something as a member vote. Now, your governing documents may say you need a higher percentage. Some governing documents say you need 2/3 of all the members to vote on an amendment to that governing document. That's still going to apply. This is just if anything is not specified as to what vote is required, this is the vote that the statute provides for us. Proxies are generally something that the association's allowed to use. It needs to be dated, include the date, time, and place of the meeting for which it's given, and be signed by the person authorizing the proxy. A proxy is basically saying, hey, you vote on my behalf because I either can't or frankly don't want to show up at this meeting. I need you to help me so that my vote is counted. A general proxy is one where you're basically saying, hey, I don't know what the hell to do here. You vote on my behalf. You decide what to do with this. A limited proxy is a little different. That's basically saying, here's how I want to vote, but I can't make it or I don't want to go. You submit this and you vote for me, but this is how I'm voting. I'm telling you how to vote, and you have to follow that. Now, a proxy is only good for the meeting where it was originally given. So plus 90 days after that if you need to adjourn that meeting in order to achieve whatever vote you're looking for or to achieve a quorum. So again, it's good for that meeting. Let's say it's set for June 27th. Okay. June 27th plus 90 days is the last date that you can use that proxy without having to get a new one. But it's still valid for that meeting and any adjournment of that meeting. If you schedule a brand new meeting, you need a brand new proxy because the proxy has to specify the date, time, and location of the meeting. But you can use the same one for 5 different attempts to actually get that member vote to amend your declaration if that's what's required. Proxies can be revoked at any time by the person that signed it. Proxy holder can appoint a substitute proxy, meaning I gave my proxy to Jason. He can't make it. He can give that same proxy to Jeff, who then votes on my behalf, as long as the form that was created to use the proxy actually provides for a substitute proxy, which is why, again, we want as many people to vote as possible. The ones that I prepare, any proxy form is going to include a blank at the bottom for a substitute proxy. And understand also a copy of the original proxy can be used if it's a complete reproduction. You leave off half a letter on the side, sorry, but it's no longer a complete reproduction. So get a good copy if you want to use a copy is really what we're saying. We already talked about this. Both limited and general proxies can be used to establish a quorum, but your governing documents might specify what is required in order to actually vote. So you might be able to use someone else's proxy to say, we had 30% of the votes represented here, so we've reached our quorum, but still not be able to get 30% of the people that showed up in person or by proxy able to vote because they used the wrong form. Electronic voting, fantastic concept. I think it's very helpful. This is where someone can vote either on a computer or a tablet, or frankly, I see it being especially useful in our more international communities where people can get on a VPN or not get on a VPN and just vote from their cell phones somewhere in France. You don't have to be sitting in your office in order to use electronic voting. And so what this does, like I've mentioned, I've used the word enfranchise. It's the opposite of disenfranchising. It's giving as many people as possible the opportunity to vote. And I'm going to be candid. I live in a 12-lot community, only 11 are built out. My neighbor is the one that collects all the ballots every time we have an election or any kind of vote. I haven't voted in the 5 years I've been living there because it requires me to get my mail, which I do, or my wife does. Okay, it requires me to open the envelope, sign a piece of paper, close it up, put a stamp on it, and walk back out to my mailbox. Haven't done it once. The reason for that? I'm lazy. Lots of people are. So if you can get people that can sit on their phone, and yes, it's absolutely one more login that nobody wants, but it's in lieu of having to show up at a meeting or find someone that's willing to show up on your behalf with a proxy. So I'm not going to go through the details of what's required because in reality, what you need to do is establish that you're going to use this by a board resolution at least 14 days before the first time you're going to use it. The resolution is something that either your attorney or the vendor you're going to use should be able to prepare. And the vendor should be qualified and should be at least recommended or suggested by your attorney, your manager, or someone else who knows people in the industry. And they're going to take care of everything else we've listed here for electronic voting. Okay, the only thing you need to know is what's this going to cost me? And a lot of them are going to actually eliminate costs and even out or close to even out with what it would have cost to mail that package to each owner. Because what they're going to do, because a lot of them get paid based on the number of people using their platform to vote, they're going to try and get everyone to opt in to vote electronically. They're going to try and get everyone to opt in to receiving electronic notices. So this is a service that benefits you beyond just the way that people vote. It can also eliminate a lot of your mailing obligations when more people in your community opt into electronic mailing or electronic notices, I'm sorry. Now keep in mind, I just mentioned these 2 opt-ins. You can't use electronic voting or require someone to vote electronically that hasn't selected and checked off a box somewhere saying, yes, I want to vote this way. For those that didn't opt in, you still need to mail that notice and mail that voting package to them or have it available at the meeting for them. But for those that want to vote electronically, it is significantly easier, quicker, and frankly, it means a lot less once you're at that meeting for the association to actually have to count ballots, separate them out from envelopes, blah, blah, blah. It's just instantaneous. You get a report instead of having to review every piece of paper. And that becomes your official record instead of the pieces of paper for those people that opted into electronic voting. So again, I know I'm not going through a lot of this, but understand that's because in reality, your vendor should be capable of doing this and should know the industry well enough to know what they're obligated to do. If you want your attorney to take a look at it, listen, this is really just a copy and paste from what's in the statute. You can read it when you get the slides like Jeff mentioned after this class. I just don't want to waste your time going through it right now. Now, I used to joke and say, oh, elections, this is going to take a while. Look at your governing documents, specifically your bylaws, section over. Because it really is, for the most part, it's that simple. This is not a condo where everything is governed by a set of statutes that are very clear and the Florida Administrative Code that says you're going to have your 60, 40, and 35 and 14-day timelines. This is look at your bylaws. Now, a lot of people are going towards that condo style election process, frankly, because most managers, attorneys, and other people in the industry just know how to do it because we do it so frequently. And it's easier. Your bylaws were probably written by the developer, and your election provision might not have ever been amended since then, and it might not make any damn sense, to be honest. We frequently come across bylaws that have election provisions that talk about staggered terms, but don't say what happens when you didn't have an election that year. Don't say what happens when that staggering gets thrown off. Don't say how to reestablish it. We have terms of 3 years, but no staggered terms. So now all of a sudden, everyone serves for 3 years and then everyone starts over. A lot of the bylaws that were drafted are just a mess. Now, we can help you clean it up through an amendment, but if you don't think you can get the members to vote on it, you're stuck with what you got. So let's get into it. A vacancy on the board caused by a director's term expiring is filled by an election. You can't just appoint someone. What you can do is attempt an election, and if no one puts their name in the hat, then you can appoint someone. Obviously, they have to accept the appointment, which is the bigger issue, because they would have thrown their name in the hat if they were willing to be appointed most of the time. Some people just don't want the stress of an election. Elections, I mentioned, need to be held at or in conjunction with the annual meeting. Whatever the governing documents say, when you're supposed to hold that meeting, that's when you hold it and how. It needs to be conducted in accordance with procedures set forth in the governing documents. Again, follow your bylaws, move forward with your life. And unless otherwise provided in the documents, a quorum of the members is required in order to hold your election. I see a lot of people mixing up the condo statute, which says you only need 30% of the members to show up, versus the HOA statute, which says 30% is your quorum. The condo statute specifies you don't need a quorum in order to hold the election. The HOA statute doesn't have that statement. So if your quorum is that 30% cap and you've got 10% of the members there, congratulations, but you're not holding an election that day. Okay, you might adjourn to a later date to try again, or you might just say, board rolls over, have a nice day. Now, unless the governing documents say otherwise, I haven't really seen governing documents that do. The directors are elected by plurality of the votes cast by eligible voters. Plain English, whoever gets the most votes wins. Okay. All members, note that word, not tenants, not John down the road who happens to have run a business before. All members are eligible to serve on the board unless otherwise disqualified. Your governing documents might allow someone who's not a member to serve on the board. But unless the documents say so, the HOA statute specifies members are the ones that are eligible to serve. Now, the people that are not eligible to serve and are otherwise disqualified, like this first bullet says, someone who's delinquent in payment of monetary obligations on the last date that they could be nominated. Now, if you're taking nominations from the floor, that's the date of the election. So if they owed money the day before, they paid it off the day before the election, there's no delinquency anymore. They're eligible to be nominated. If you had a nomination process 15 days in advance and they were delinquent as of that date, I don't care that the election is not for another 15 days. they're not eligible to serve because they couldn't be properly nominated at that time. Now, the thing to be careful about is this blue word here, delinquent, doesn't necessarily just mean their assessments are past due. A lot of governing documents, and this is generally going to be in your declaration, in your assessment provision, and specifically the lien provision that says what happens when someone doesn't pay on time. A lot of governing documents specifically say you are delinquent if you are 10 days past due. Well, the statute says delinquent. So if they're past due on the last date that they could be nominated, but they're not delinquent according to the governing documents, they can still serve. So don't end up with an election challenge by not spending the 5 minutes to have your attorney take a look at what is delinquent and what is past due. A person who's been convicted of a felony in Florida or something that would have been a felony if it occurred in Florida and hasn't had their civil rights restored for at least 5 years. Plain English, they haven't been out of prison for 5 years yet. Okay. Someone that has that condition cannot serve on the board. Now, if you find out after the fact, you didn't know because most communities don't do background checks on their potential directors. And no, I don't recommend going ahead and creating that new obligation that you never had and the statute and your governing documents don't impose, because then all you're doing is setting yourself up for failure. But if it's a no harm, no foul statute here, if you didn't know that they were convicted of a felony and hadn't had their civil rights restored for at least 5 years, then anything that they voted on, anything they did as a director is still valid, but they're off once you find out that this happened. Another disqualification category is pending criminal charges for any crime involving an HOA. Sorry, but if you are under indictment, you cannot serve on a different HOA board or the same HOA board. I think that one makes sense. Members can nominate themselves as candidates at the meeting where the election's to be held, unless you are using an advanced voting system. And the reason for that, if you're going to allow mail-in ballots, if you're going to allow voting in advance of the meeting, you're precluding that person from having the people that are submitting those ballots in advance from actually voting for this person. It's not fair. And we don't always care about fair in HOA land, but this time we do. So that's something to keep in mind. Now, one thing that I don't think is in the slides is, how do we disqualify votes? What are we not going to accept? And in reality, it's only a few things. One, if someone voted more than once and doesn't own more than one lot, both those votes are canceled out. We're going to mark them as disqualified or discarded, something similar. Because you can't figure out and you can't presume, and frankly, the association doesn't have the ability to ask which of those 2 or 5 ballots that person intended to submit. So those are just disqualified. Similarly, if we have a requirement that we're doing the inner and outer envelopes like we would in a condo, and you have to write your name, address, or lot number, blah, 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 on the outer envelope, and the association can't figure out what the hell the thing says because they can't read your writing, the board can ask, but they don't have the obligation to do that. So if we can't figure out who's voting, we can't verify that that person is eligible to vote. And so that entire envelope is marked discarded and moved to the side. And then finally, keep in mind, the fact that someone wrote their identifying information on an inner envelope or on the ballot itself, not going to disqualify the vote. You're just going to write down that that person waived their anonymity. Now, I said finally, I thought of one more. I apologize. If someone votes for more people than there are spots available on the board, so you've got 5 open positions, someone voted for 6. Same thing as voting twice. The board doesn't get to unilaterally decide, well, you know what? Alan's on the ballot. That guy's a jerk, so I'm crossing his name off, and the other 5 will count. Doesn't work that way. Now, if someone votes for less than the number of candidates that are eligible to serve, totally fine. Okay, you're just going to count those 4 votes. You had 5 open spots. They voted for 4. Those 4 votes still count. The 6 don't. All right, moving on, because that's what we do. Election by acclamation is another possibility. This is where essentially you've got that same 5 open spots, but only 4 people or 5 people put their name in the hat to serve as candidates for director positions. Why would you waste your time holding an election when the same number of people want to be on the board as you need on the board or less? They're on the board. So you just, instead of holding the election, your meeting will essentially be skip the election, announce the results, and that's it. Those people, presuming they're eligible, will all serve. Members do have the right to vote in person or by proxy unless the governing documents say otherwise. If you are allowed to vote by secret absentee ballot, that's where you're going to follow that portion of a condo style election. Blank inner envelope, ballot inside of it, outer envelope identifying who's voting. If you need a proxy, that presumably goes outside of all of those. Otherwise, you're waiving some anonymity, which again is fine. That's it. Now, if the bylaws don't specify the term for each director, that's automatically 1 year. If someone says, well, you didn't follow the proper procedure, or you didn't put my name on the ballot and I should have been on there, and so no one voted for me and I should have been elected. You only have 60 days to bring that challenge. And there are only 2 places to bring that challenge. One is with the division. That's the DBPR. It's essentially a government entity that will assign an arbitrator that is paid by the government to that matter and will decide your fate for you. Those arbitrators have explicitly said we're allowed to decide in an arbitrary manner. They don't often follow protocol. They don't often follow precedential law. And so if you're going to be stuck with an election dispute, my suggestion is go with the other option, which is filing a lawsuit. Because at least if you're in a situation where you're stuck in front of a judge, yes, it may take a while for that judge to make a decision on the issue, but at least you're sitting there with precedent being followed. Now, on the owner's side, although we don't really counsel owners here very often, frankly, an arbitration petition might be great because chances are you're wrong, and chances are there are things that the association did that should be excused, but the DBPR seems less inclined to excuse them if it's something that was done by an association instead of by an owner. So bottom line, 60 days. If you don't raise that election challenge, meaning you file your arbitration petition or your lawsuit within those 60 days, you've waived it. And keep in mind, if you're going to arbitration, you do need to provide a pre-arbitration notice of the intent to file for arbitration. And that is something that we frequently do see having people get knocked out of arbitration because they didn't submit that in advance, letting us know, hey, if you don't hold a new election, I'll file a petition. You didn't give us the option to fix it first. And you're wasting DBPR's time as a result because it could have been fixed by just holding a new election, but you didn't tell us anything was wrong from your perspective. All right, moving on and off the soapbox. Officers are appointed by the board, usually at the organizational meeting, which immediately follows the election or the announcement of who is on the board. Directors can't vote by proxy or secret ballot, meaning their decisions are generally made in an open format, except that secret ballots can be used in electing officers. I've never actually seen secret ballots being used in electing the officers. Usually it's, John, do you want to be the president? Yeah, sure. Okay, all in favor? Aye. And you go through all of the officer positions and you move on with your life. Now, keep in mind, when John, the president, hasn't taken a board certification class, doesn't know that being president doesn't mean he can unilaterally act and do whatever the hell he wants, well, that's when you might step in and say, all right, the next agenda is going to include an agenda item called officers. And we're going to pull John off as an officer. Even though he's still a director, he's still on the board, we're not going to leave him with that apparent authority to do what he wants. Now, before you go to that extent, I'd suggest having management point out, having the other directors point out, and if it gets to this extent, having counsel point out that no individual director has the automatic right to do literally anything on behalf of the board. They have the right if that's been delegated to them by the board. But if you get through those procedural hurdles, which are not required, but they're my recommendation anyway, and this person still won't do what they're supposed to do, they keep knocking on doors saying, you owe us money, scumbag. not really favored in community associations. Okay. If they're still doing things like that and they just won't listen, you can pull them off the board. All it takes is a board vote at a meeting where there's a quorum of the board. All right. Fraudulent election voting activities is a first degree misdemeanor. I'm not going to go through what they are because honestly, if you can't figure out what election fraud is, you're probably the one doing it, and this is not going to help you because you're not going to listen. All right. So bottom line, don't try and impact someone's vote by changing it, threatening them, or bribing them. That's really the main gist of this slide. Let's see. Here's the important one, though. Anyone that knowingly aids, abets, or advises someone in one of these fraudulent voting activities also commits a first-degree misdemeanor. So knowing that someone committed election fraud and not reporting it is technically a crime in and of itself. So this is one where non-snitches get stitches. We really want you to actually report if you know that the election was not done right. And specifically, if it's basically knowing about fraudulent activity, you need to report it according to Florida law. Vacancies on the board, unless the bylaws say otherwise, if there is a midterm resignation, removal, anything other than a recall, which will be discussed later, okay, that can be filled by an affirmative vote of a majority of everyone that's left on the board. Even if there's less than a quorum, or even if there's only one person left on the board, you can appoint the other people to serve with you. The alternative is you can hold an election to fill that vacancy. Frankly, I don't know why you'd go through that hassle if you're not required to. I had someone during our board certification earlier today basically say that you're not being transparent enough and you're not giving the members their say. You gave them their say by voting on who's on the board in the first place. And presumably, because the statute gives them the authority as the directors to decide to appoint someone, you also implicitly gave them the authority to go ahead and do that in accordance with the statute. So I don't necessarily agree with that person, but they're entitled to their opinion. Everyone's entitled to be wrong once in a while. That's fine. Except attorneys, we're not allowed. Unless the bylaws say otherwise, a board member appointed or elected to fill a vacancy basically serves until the expiration of that term. Okay, moving on to board meetings. We've already covered some of this. What is a board meeting is a big question that we get asked constantly. Technically, the statute says a board meeting is any time a quorum of directors is meeting to conduct association business. Now, the question is, there shouldn't be a question as to what a quorum of the directors is. That's clear. What is conducting association business? Is it we're going to discuss which of these 20 bids we're actually willing to consider, and the last 5 that we're actually willing to consider we'll discuss and vote on at a board meeting? I've had people say that even that is conducting business. I don't agree. My perspective is unless you're voting on something, you're not conducting business because a vote is required to conduct business. But a lot of attorneys disagree and you might get sued. So I'm required, although I don't like it, to give you the, hey, there's some risk if you're doing anything as a quorum of directors, just don't talk about the association at all. You can talk about your neighbors, not really nice, but so be it. But just don't talk about the association business. Now, you can communicate via email. So the same thing that I said I think is fine to do in person, you can definitely do it by email. You just can't vote by email. So the statute's even clearer on what you can and can't do via email than what constitutes a board meeting. Now, if there's a board meeting, it needs to be with notice and it needs to be open to the members unless there's an exception that applies. So be careful there. Officers and directors. This is probably the most important part of a board certification class. It's very important here too. Officers and directors of an association have a fiduciary responsibility to the corporation, meaning to the owners, but really to the business. Okay. The fiduciary duty is the highest duty imposed by Florida law. You're basically a trustee of the association at this point. The good news is, I like to say you're judged by the dumbest guy in the room standard. Okay, what we're really looking at is the business judgment rule. If you reasonably believe, based on all the information available to you, not just the information you have, but the information that's available, meaning if you ignore advice of counsel, if you don't ask your manager something that you're not sure on, and they might have had information, sorry, but this might not apply. But if you rely on all information available to you, and a reasonable person in your shoes would have made that business decision or could have made that business decision, you're protected from personal liability. Now, personal liability meaning you get sued as an individual. So make sure you've got directors and officers liability insurance. Otherwise, I wouldn't serve on a board. And make sure that the indemnity provision in your governing documents actually protects you. But more importantly, rely on the advice of your experts. If you don't like their advice, find different experts. Or just acknowledge that you might not like their advice, but it's still right. Okay, so if I tell you that the Florida statutes don't allow you to do something a certain way, chances are I'm going to say, well, you can do it this way instead, and that's allowed, and get creative so that you can still accomplish your purpose. But if my response is absolutely the hell not, you will get not only sued, but probably thrown in jail. Maybe you shouldn't do that thing. Okay? So that's the type of guidance we're saying. Don't ignore advice of counsel or other experts. That could be your manager, your architects, your engineers, all the people who you don't need to get bids for. Those are the people that, in my opinion, are people you should be relying on their opinions. Okay. Unless the governing documents say otherwise, the board makes almost every decision, like I said earlier. And unless delegated, we talked about no one board member should be deciding. Directors can't vote by proxy or secret ballot, except electing officers. And I mentioned using email as a means of communication, but not to vote on association matters. Now, board meeting notices are exactly the same as member meeting notices. The difference is the time frame of how and when you post the notice. Okay, we talked about 14-day mailed or emailed notices for member meetings. In 99% of board meetings, it's only a 48-hour posted notice. Okay, it's conspicuously posted in the community at least 48 hours before the meeting. That also applies to closed meetings with counsel. So you still need a notice, you still need an agenda, you still need posting. It's just not open to the members. Now, if you're talking about a special assessment or you're talking about rules governing use of the lots, not use of common areas, use of the lots is what the statute says. That is a 14-day mailed notice instead of 48 hours posted. And everything, we talked about the website before, everything that you would need to put up at a member meeting needs to go up 48 hours in advance of a board meeting as well. So if you're signing a contract, that goes on the website 48 hours before the meeting. You also post your notice and put your notice and agenda on the website, blah, blah, blah. All the same things, just different timelines and locations. We just talked about that. Okay, we talked about that. Now, just like the members get to attend and speak at member meetings, same deal at board meetings. I said we'd be able to skip some of this. Same thing. The difference is, unlike a member's right to speak at member meetings, there's no statutory time limitation. Okay. I would suggest adopting a 3-minute time limitation for all meetings, because there's nothing in the statute that says how long members have to speak at board meetings. You may say, oh, Robert's Rules of Order says blah, blah, blah. Robert's Rules of Order is not intended to govern HOA meetings. It is literally described as parliamentary procedure. Y'all ain't parliament. Sorry to use that terminology, but the reality is you are not in a parliamentary meeting. You're in an HOA meeting conducting business. No other commercial venture, in my opinion, should be using Robert's Rules as their guideline. They should be using it as something to refer back to for certain aspects of the meeting, but not how to run the whole meeting. Same thing with recording and handicapped access, as we mentioned for member meetings. Directors do not serve for compensation unless they are participating in the same financial benefit as everyone else. They're being reimbursed out-of-pocket expenses that have been approved by the rest of the board. They're recovering insurance proceeds that are for a policy maintained by the association, just like all the other members. And then if a fee or other compensation is authorized either in the governing documents or by a vote of all voting interests of the members. So you can pay directors and officers or committee members. I've never seen a group actually sit down and say, we don't have to pay these people, but we think we should. Haven't seen it happen. Not saying it'll never happen, but in 18 years of community association representation, haven't seen it once. And then the other thing is a developer representative is entitled to compensation by the developer, not by the association. Grounds for immediate removal, you do something with respect to elections, theft or embezzlement of association funds or property, tampering with physical evidence to try and get away with a crime, obstruction of justice, or any criminal violation under the HOA Act. Now understand, I'm going to go back to the opening portion of this slide. A director or officer charged by information or indictment is removed from office. Not charged by Jason because he doesn't like my face. Okay, which would be fair. But it's not John down the road. It's not John down the road said, I watched Alan steal a whole bunch of money. Y'all got to pull him off the board. No. It's information or indictment. These are legal terms talking about criminal charges being brought against this person. If there's no police officer willing to submit this charge to a prosecuting attorney who is then willing to pursue the claim, this person doesn't come off the board. Now, once that claim is filed, they're immediately off the board. So understand, this is grounds for immediate removal, and it only happens when that criminal charge is actually brought by a prosecutor. The board fills the vacancy until the end of the term or the end of the suspension. The suspension ends if that person is brought, is found not guilty or the charges are dropped. So even if you appointed or elected someone else to fill that role because you figured, this guy's definitely getting convicted, I watched him do it, that's not the end all be all. If they end up back on the board and their term hasn't yet expired, then they sit back in their seat. The person that was elected or appointed comes off the board automatically, and you have to allow them back in. Now, if that criminal charge is still pending, that person can't be appointed or elected to any association board, can't serve as an officer on any association board, and can't review, access, or otherwise touch any association records of any community in Florida except pursuant to a court order. So that person would have to go back to the criminal court where they're being prosecuted and say, I need these documents, please allow me to see them. Also, anyone that's more than 90 days delinquent in payment of any fee, fine, or other monetary obligation to the association is treated as abandoning their seat on the board. For practical purposes, again, look at what delinquency means. Don't just presume that it's past due by 90 days. Okay, delinquent is the term that's used in the statute. And make sure that they're actually past due. Accounting mistakes happen. But before you tell someone you're off the board forever, or at least until the next election, or if the board decides to reappoint you, make sure you're correct. But that is grounds for immediate removal without any kind of court order, without a board vote, without a member vote, without the manager having to do anything. This person's just off the board. Now, what I also suggest considering, people, I usually get this question, what about people that just don't show up at board meetings or never vote? They're on the board, but they haven't done jack. My response is you need an amendment to your bylaws that says failure to participate in any 3 consecutive meetings is treated as an abandonment of your seat on the board. Now, there's a big difference between the board voting you off and abandoning your seat. Because the statutes basically say the only way to pull someone off the board, other than one of these basically criminal acts, is a recall, which is a majority vote of all the members. And that's a lot bigger headache than saying you didn't show up 3 times, you're off the board, have a nice day. So just something that I suggest considering. Conflicts of interest, it's basically whenever a director, officer, or relative enters into a contract with the association. Okay, when we say relative, we mean within what's called the 3rd degree of consanguinity. I like saying that word because it sounds fancy, but it's really just great-grandparents, great-grandkids, siblings, spouses, kids, every level across and up and diagonally for 3 levels of family. Now, keep in mind, a conflict isn't always bad. Me working with my brother might get the association the best possible deal because my brother wants to make sure we're taken care of and he doesn't want me spending a whole bunch of extra money that I don't need to be spending. Great. Just disclose it. How do we disclose it? Well, you got 14 days before the voting is going to take place. You got to disclose it. You have to put it on the agenda, on the notice of the meeting. You have to have at least 2/3 of the other directors vote in favor of that contract in order for it to pass. It needs to be reasonable and fair to the association. The director who has that conflict needs to step aside. They can present the contract, but when the voting is going on, they need to step out of the room altogether so that they're not influencing the vote when the discussion and voting happens. They're out of the room. The vote takes place, they can come right back in. Now, at the next regular or special member meeting, the contract's existence and that the conflict needs to be disclosed again to the members. And at that meeting, the members get to say whether they want to cancel the contract. In order to cancel it, excuse me, one of the members needs to actually make a motion to terminate that contract, and a majority of I think it's all those present. Yep, a majority of all those present at the meeting need to vote in favor of termination. If it's terminated, the association pays only for the value of the services provided or goods provided through the date of termination, but none of the termination provisions of the agreement are going to play in. So if there's a termination fee, if it was a 5-year contract and you're only 3 months in, you're not paying the rest of that contract. Okay. Moving on. Posting, we mentioned the agenda and anything you're voting on needs to be posted. Membership meetings, we already talked about, so we'll skip that. But if it's a board meeting, it's 48 hours. Member meeting, 14 days. Meeting minutes. Every meeting needs minutes. They do not need to be 20 pages long. They don't need to be a verbatim record of what was discussed during the meeting. If someone wants to record the meeting to have that record, that's their prerogative. Let them record it. But the association is not going to provide the evidence that John down the road, and if you're John and you live down the road from me, I'm not talking about you, I promise, that's just a generic. But John down the road says, well, guys, this contract that you're about to sign is a horrible idea, and here are the 20 different ways I see it going wrong. And then it goes wrong 19 of those 20 ways after you sign. Well, if you're taking verbatim records and you're basically saying, oh, John down the road wanted it noted for the record that he has these concerns. My response to noting for the record is note it your damn self. We don't have an obligation as an association to create that record for your benefit. The association's obligated to report on the minutes, here's the motion that was made, here's who made it, here's who seconded, here's how every director voted, here's who abstained, here's the result. That's it. Those are the minutes. That's all that goes into them. The motion, the vote, done. So if you're doing more than that, all you're doing is giving everyone the ammunition that they want. You're not obligated to give your members the ammunition to sue the association later. Okay. Notice and adoption of the budget. Governing documents need to be reviewed. A lot of them will specify that you need to give some kind of ridiculous 30, 40-day notice before you adopt your budget, that the members get to vote on the adoption of the budget, blah, blah, blah. So don't just presume that what's in the statute is good enough. It may not be. If the governing documents are silent, then technically it's a 48-hour notice before the budget gets adopted, just like any other board meeting. Now, keep in mind, a lot of people are going to say you need to give 14 days notice. Well, that's what the statutes talk about, special assessments, 14-day notice of a board meeting. Doesn't say any assessments. It says special assessments. So a lot of people will comply with that 14-day requirement, even though it doesn't exist, just to avoid that argument. And I'm in favor of doing that. There's no reason you shouldn't be able to say 2 weeks before your budget's being adopted, here's what we plan to adopt. Because keep in mind, you can always amend the budget during that meeting, and you don't need to give a separate notice or hold a separate meeting. So give it your best shot. Here's what we're looking at right now, 14 days in advance, and then no one can argue that you didn't comply with a requirement that doesn't exist. Consider sending it to all members prior to adoption. You're not required to do that. but you do have to send it after the fact, or at least say that a copy is available upon request at no charge to the member once it's adopted. If it's requested, a copy must be provided to the member. This is basically a records inspection request, but you're not charging for a copy of the budget. And it also goes on your website if you need one. Special assessments, I mentioned earlier, 14 days notice to the members, board vote in general. Keep in mind your governing documents may say that you need a member vote. Generally speaking, if it's an obligation of the board, it's an obligation of the association, and the members vote something down, you're still allowed to go ahead and do it because it's a decision between violating that member vote requirement and violating the obligation to properly operate and maintain the association. Your fiduciary duty to the members in the association is generally more important than the requirement to get a member vote to adopt what you're required to spend. That doesn't mean you shouldn't try and then go forward with it anyway. What I would also strongly suggest, if you're going to do it without the member vote that's required under your governing documents, get a written opinion of counsel citing the case law that says you're allowed to do it that way. The notice includes a statement that a special assessment is going to be considered, says the amount of the special assessment, the nature of the special assessment. Then after you hold the meeting, you have to obviously notify the owners of what's due, when, and the nature of the special assessment yet again. Committees, generally speaking, you can adopt whatever committees you want. There are two types. One is board, one's advisory. The ones that are going to be telling you how to spend your money as a board, or who are telling you what the architectural decisions are or should be, are open, noticed meetings. The other ones are generally not. I'm going to skip a little bit because I know I'm running a little behind, but that's generally how it works. Same meeting requirements and openness requirements apply to committees that final decisions are being made regarding expending funds and having the power to approve or disapprove architectural decisions. So that's what we're talking about here. Fining and use suspension committees, architectural, blah, 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 are not subject to notice requirements. But the person who is being fined, suspended, etc., that is going to be a notice to that person. It's just not open to everyone, and it's not a notice that goes to the entire community. It goes to the people whose property or whose person you are working on. Fines, I think, are a waste of time. All they do is slap someone on the wrist and say, you owe me money that I'm never going to try and collect. But if they work for your community, congratulations, you're one of like 5 in the state. But I'm going to go ahead and not jump on that soapbox beyond that comment. The association is authorized to fine and suspend use rights. If you want to suspend voting rights, your governing documents need to allow that. A fine or use right suspension can only be imposed if the board first votes on it at a properly noticed board meeting. And if you're doing this for something other than failure to pay a monetary obligation, you also need to provide a 14-day written notice of a hearing on the alleged violation. It provides a description of what was done wrong, what needs to be done to cure it, and the date and location of the hearing and access information if it's going to be held virtually or by phone. Now, all of this needs to be done, and the owner has that full 14 days to cure the violation. If they cure it before the hearing, or they somehow convince the hearing committee that there was no violation, or that, oh, please have mercy, which is not the authority that the committee has, but they'll do it anyway, to just grant mercy. That's called selective enforcement, by the way, but I digress. If that committee decides that they don't want to levy the fine or the suspension, okay, dead in the water. Can't do it. Even though the board, which is the decision-making board, said, hey, we got to do this. That's what the statute says. So again, kind of feels like a waste, but that's okay. The hearing must be held within 90 days after the hearing notice. The committee needs to be comprised of at least 3 people who are members appointed by the board. They're not officers, directors, or employees of the association, or they're direct family members or officers, directors, or employees. That committee just decides yay or nay by majority vote whether to impose. If they say no, it can't be imposed. If they say yes, you have 7 days after the hearing to mail or email written notice to the violator that their rights are suspended or they owe a fine. For 30 days after that, you can't spend attorney's fees trying to collect the fine. So you're giving them what? 60 days minimum. during which they will have done nothing to cure the violation, or they'll have cured it at the last minute, so you can't levy a fine or a suspension. Okay, we've already touched on all this. You can get your fees and costs back, but not until after you file your lawsuit and win, if you're trying to collect fines. And so you're going to spend 5-10 grand to go after $1,000 in fines. You're going to get your money judgment. It's going to say you're owed a bunch of money. And then what? Are you really going to spend more attorney's fees trying to collect that money? Probably not. So this is why I say go after injunctive relief, go after alternative options. Fines can't exceed $100 per violation unless the governing documents say otherwise. Can be levied up to $1,000 for a continuing violation unless the governing documents say otherwise. And fines of $1,000 or more can become a lien if the governing documents say so. And the right to suspend those use rights, that's basically amenities only. It's not the portion of the common areas used to provide access or utilities to the lot. Can't prohibit vehicular or pedestrian ingress or egress getting to and from the lot. You can't suspend the right to park, and that suspension does arise against everyone affiliated with that lot. You can't fine regarding leaving trash out at the curb 24 hours before or after garbage time. Now, this does not mean that you have no enforcement mechanism. It just applies to fines. I've had a lot of people since this law came into effect, I think it was 24. I've had a lot of people saying, oh, we can't enforce this violation anymore. Well, if all you're doing is fining, you weren't enforcing jack before anyway. Okay? You can't fine for it. You can do anything else that you were able to do before. Leaving holiday decor out for too long is another one. Sorry, but no, can't do it. All right, moving on. Association can suspend for failure to pay if the owner's 90 days delinquent. Remember, we talked about what delinquent means. And any monetary obligation due to the association, that is a board-only vote. Same thing. You can't fine without a meeting, but you can suspend if it's for monetary obligations without a hearing. It's just a board meeting. But you do need written notice of the suspension that gets sent to the owner. Suspension of that, same thing. Suspensions don't apply to certain areas, and the suspension applies to everyone. It ends immediately upon full payment of the delinquency. Now, if they owed $50,000 and they pay $49,000, that is not full payment of the delinquency. So understand, until they pay every penny they owe you, they're still suspended. There's no, in my opinion, there's no reasonable time frame requirement when it's for a monetary obligation. It's until you pay. All right, voting suspensions, again, same rules required, same procedure required. You got a board meeting and a hearing. The only difference here is that unless your governing documents specify that you're allowed to suspend the right to vote, or your governing documents were recorded after July 1st, 2011, when this right to suspend voting rights actually kicked in, you can't do it. So it's one less thing you're able to do. Now, a voting right that's been suspended doesn't count for any purpose, doesn't count towards a quorum. So you're actually removing them from the rolls altogether for any vote that's taken by the members during that suspension. So the suspension in that one, again, ends upon full payment of the delinquency. Now, there is also the right to suspend voting if your declaration says so for violation of the covenants. I don't think judges love that one, but if it's in your governing documents, same deal as a use right suspension, same procedure, and it ends presumably when the violation's cured. And that's all we've got. I'm going to take some Q&A, but I want to leave it open to Jason if he had anything he wanted to add before I jump in, or Jeff, if you all want to add anything before you jump in. Thank you to everyone for hopefully listening, and I hope you got a lot out of the class. I'll jump into the Q&A in just a moment.
Thank you. Jason, if I may, just for a second, I just want to reiterate to everybody, if you haven't already, press the chat button so that the chat module appears on your Zoom interface. Please do that now. We already placed the evaluation link in there twice, but if you haven't already pressed the chat button, you will not see it when you come in. So press the chat button so it shows up, not to be confused with the Q&A module, two different things. And I'll place the evaluation link in there again in just about a minute or so. Keep in mind too, And please listen up because I guarantee this will come up in about 5 minutes. Um, this is the Q&A part. We want you to hang out. We want you to stay on as long as we can, believe me. But this part is not required. Now that the slides are done, after you click the link and fill out the evaluation, the required part is over and you are free to go, and you will get your certificates via email in about 10 business days or less to the email address you enter on the evaluation that I just talked about. So again, press the chat button. I will now shut up and turn it back over to Alan and to Jason.
Thanks, guys. Alan, I think one that's, not in the slides, but it came up a little bit. It's in a couple of the questions, and it comes up for us a lot, is really meetings like this one, right?
Yeah.
What can be done around a video meeting, whether it's Zoom or Teams or whatever your platform is? There were a lot of significant changes that came up related to 7, 18, and 19, and people sort of, confused the three. So there are a few of those in the Q&A. So I'll just point you that way a little bit.
All right, well, we'll start there. That's obviously important, especially when this is the topic. I mean, the reality is anything that qualifies as a meeting, which again, if you're talking about a board meeting, it's conducting association business, needs to be open to the members. But if you're doing an education program, if you're in a mediation, none of that needs to be open to the members. If you're meeting with counsel to discuss attorney-client privileged issues, that can be closed. Okay, so there are things that require a meeting, that require openness, but a meeting like this, your board is not discussing association business. They don't even have the ability to discuss anything because it's me talking.
Yeah.
And it's Jason and Jeff talking. So an educational program, if you go to the CAI, any of the chapter trade shows, you go to any other trade show, you go to an educational session, we do an in-person, you take a class like this, that's not going to be a board meeting. Okay. Now you might start talking about things that make it a board meeting and be careful with that. But the reality is, if you're not making decisions, again, my perspective is if you're not deciding anything and you've consciously stated nothing gets decided today, not really a board meeting because you're not conducting business. But again, there's really no case law that I've been able to locate in 18 years of practice that defines what conducting business would even mean. So, again, whether you want to be a little bit more risk averse and say, we're not going to do it this way, we'll send emails later today, or honestly send emails when you're sitting next to each other instead of speaking out loud. Somehow the legislature says that's okay. But if you were saying it out loud, now all of a sudden it's a problem.
It's crazy. When I was out on the field, I used to just tell my staff and even the board members, you're damned if you do, damned if you don't. If you don't do enough research before the board meeting, you get criticized for not having all your stuff together and not knowing the material. Then you go ahead and do the research, collaborate. Then you can get criticized for having an illegal board meeting. I mean, what do you do? Damned if you do, damned if you don't.
I mean, I think candidly, the only thing that the board really can do to protect from that damned if you do, damned if you don't is to make a conscious decision and have in a resolution, this is how we're going to deal with these issues. If anyone has a problem with it, they need to let us know.
Yeah.
So that, and my recommendation would be do at least the minimal evaluation of, is this even something we'd consider before you waste the time at a board meeting having a full discussion on that topic. And then if it's something that you'd actually consider, then you discuss it in full during the board meeting. But I think if you have something in writing somewhere, even if it's just part of your, participation at meetings policy that dictates these certain things we have been told are probably not problematic to do on our own so that we don't have to have a 5-hour board meeting to evaluate the 20 proposals we've received for landscaping services. We're going to narrow it down to 5 and we'll do that full discussion in front of everyone. It just doesn't make sense to me to limit the ability to say we would never do business with these people. I don't know why this is even being discussed at the meeting. It's illogical. That doesn't mean that the law says it's right. So that's about the best I've got is have a policy. And if someone has a problem with the policy, they can bring that up.
Fair enough.
All right. Well, it looks like we've got about 24 questions so far. Let's see. And understand, I'm only looking at the Q&A, not the chat, as Jeff mentioned earlier. The chat is for technical issues. So Tammy asks, 3-minute rule. Is this before the items voted on or after? Totally up to the board how you want to handle that. My perspective has always been if you do it before you vote, then the members feel like their opinion has been heard and considered. Even if you're not considering their opinion, at least you're not sitting there and saying, yeah, I don't really give a crap what you guys want to say. You can say it after we've already made the decision, and chances are we'll be leaving the meeting before you get to speak. I just think that's a way of being, I don't want to say less transparent, but less accommodating and less giving an opportunity for the members to feel heard, even if they're not actually being heard.
It's kind of the spirit of the law and the letter of the law, right?
Correct. The whole purpose of saying everyone has 3 minutes to speak is that hopefully you're considering what they're actually saying when you're making your decisions.
Yeah.
Who decides whether a limited proxy or a general proxy is used is what Stephen asked. Your governing documents make that decision. So not something I get to decide for you or you get to decide for you unless that's through an amendment to your governing documents. Mike asks, at a regular monthly meeting, is it okay to have an open forum for the homeowners to discuss anything they want, including the agenda? But during the regular business board meeting, we don't take questions or comments. Is it okay? Yeah. The problem is once you start letting people talk about an issue, everyone else gets to talk about it too. So if you have that open forum, what I would suggest is you actually hear what people have to say on the agenda items during the meeting and then have that open forum as a non-meeting for anyone that wants to voice their opinion, either before the meeting or after the meeting, so that you're able to conduct your business, but you're still hearing people out. Samuela asks, at our annual meeting, there was no election since the same number of openings were filled by the same number of candidates. However, there was also no quorum. Can the reorganization take place without a quorum? That's a question we get pretty regularly. And honestly, there's nothing in the statute that says how to handle it. Most people will say, we want the people that want to serve to be able to serve. So we'll seat the new directors. Others will say, well, we're going to try and get a quorum so that we can do this the right way. And others will say there was no quorum, so the new directors can't serve. We just roll over another year. Honestly, ask your attorney for a written opinion and pray is really all I've got on that issue. Ira asked, do absentee ballots count towards a quorum at an election meeting? 100% yes, presuming that your governing documents allow for absentee ballot voting. If you're taking nominations from the floor, perhaps not, but hopefully your governing documents allow it. Renata, we haven't had an annual meeting in 20 months and none of the board members completed any required education for 2025. What should have happened? Are they eligible to run at the annual election without the required education? Anyone can run without education. So that's not an issue. But the fact that technically all of your board is off the board might be time. I hate to ever even suggest the R word, but not a recall necessarily, but you might be not having a board. And I won't mention the word that I'm thinking of that I really don't like hearing. But in reality, you might end up filing a lawsuit to get a new board created. Renata, our HOA docs don't allow for advance notice of candidates for board positions, so there's no mailed ballot since no names. What's the protocol for self-nominations? Time allotted, questions allowed on candidate positions, etc. That's decided by your board. I would suggest setting it up in advance of the meeting, but in reality, if the bylaws don't dictate how that's supposed to go, your board gets to decide in advance, and hopefully they do decide in advance instead of deciding based on who actually puts their name in the hat during that meeting as to whether they're going to get an opportunity to speak, etc., or just have a bunch of names. Obviously, you should be giving people the opportunity to express their qualifications, whether you have the same 3-minute allotment as you would normally give, or you just give, 5-10 minutes per person, totally up to the board. Robert says, to be elected, does your name have to be on the deed? Property in only one spouse's name and not the other. Depends on your governing documents. Technically, only the member is eligible to serve, but if your governing documents say you don't need to be a member in order to serve, then yeah, doesn't matter. The alternative, and I'm not going to give you legal guidance on how to decide whether you want to be on the deed or not, but the alternative would be to get onto the deed and have your spouse put you on there. But the reality is, it's going to depend on what your governing documents say as to who is entitled to serve. And you should have a provision of your bylaws that says who the directors can be and who the officers can be, what their qualifications are. Angela asks if our governing documents allow someone to be on the board that is not a homeowner, partner's not married, so not a member. Does the state override that? Nope. Governing documents control there. Robert asks, after turnover, you have 10 days, not sure of calendar or business to conduct an organizational meeting. What notice is required to give to the owners? Well, hopefully it's being given as part of the notice of the turnover meeting. If not, it's 48 hours just like every other board meeting. Jonavette asks if a person quit the HOA board, can they be slow back in? I think that means can they be added? And the answer is yes. But it's going to be optional on the part of the remaining directors whether someone who quit is the right person to continue running your HOA. Lizeth asks if my condo docs don't have Kaufman language, do these limitations apply like criminal record or delinquencies? Yes, because they are part of the procedure for who may serve. And also, it's a matter of protection. Keep in mind also, if you're talking about your condo docs, you're possibly in the wrong class because you're not getting credit because this is an HOA class. Tammy asks, can board members attend monthly board meetings via Zoom? The answer is yes. Let's see. Renata, our annual meetings within 90 days of the due date of our annual maintenance payment. If a homeowner was delinquent at any time during those 90 days but eventually paid the overdue amount, are they eligible to run for a board position? Renata, the answer depends on when the last time that they could be nominated for a directorship actually was. Was it during the meeting or some other time? So that date is going to be determined by when the last time you were eligible to put your name in the hat as someone willing to serve. Stephen, how about if the board member fails to provide their education requirement after 90 days? Does that require immediate suspension until provided? It doesn't require it. It creates an automatic suspension if they haven't provided their, and keep in mind, when we're talking about the 90 days, it's only the HOA board certification class. These classes, you have a full year to do your 4 or 8 credits. Mickey asks, hi Mickey, how you doing? If a president doesn't have a completed board certification class, how long can they stay a director and what action does the board have to take? Same answer. If they haven't done the board cert within 90 days, they're off the board until they get that certificate into the official records of the association. There's no action the board has to take other than reporting that you've noted it and they're off the board. It's not a board vote, it's a report. Brad, good to see you. If our documents allow for the board to raise the assessment 3% per year without member approval, and the board plans to raise the 3%, do we need to do the 14-day notice of the 48-hour? Keep in mind, 14 days was just because people will complain. And Brad, in your particular community that I represent, they will complain, and I would recommend going with the 14 if you can. If you can't because you just got to get this done, 48 hours is all that the statute requires if you're not doing the member vote. If you need member approval, it's definitely at least 14 days notice because it's now a member meeting, not a board meeting. Tammy, for the 3-minute rule, do members get to speak 3 minutes before the agenda item is voted on or at the end of the meeting? Again, up to the board, but I would suggest before it's voted on. Sean, I'm sorry, but your question was like 3 paragraphs, so I would suggest that you go ahead and email me, and I'll do my best to answer another time. Lena asks, what can we do if a resident has a violation and then cleans up in time but continues to do it again and again? So this is where you have a covenant enforcement policy and your fining or suspension policy says that someone who does this more than 2-3 times in a 12-month calendar period is treated as an ongoing violation even if they cure it. So this is basically, there is case law that says you can still get an injunction if the likelihood of recurrence of the violation is, well, we expect it to happen again. So that's where I tend to add to your enforcement policy a provision that says if you violate more than 2 times in any calendar year, on the 3rd one, it's just treated as ongoing even if you cure it. You won't be able to fine for it. You won't be able to suspend use rights for it because of the way that the statute is worded, but you can still pursue enforcement either via self-help, if it's a self-help issue and your governing documents allow for it, or via an injunction, which is the way that I recommend everyone pursue covenant enforcement because then it's a permanent situation rather than a temporary fix. Nicholas, there's a rash of predatory fining with legal that I have noticed in Miami and now seeing in Orlando, excessive fees. It's not approved by the HOA. He helped 15 families take it to small claims court. I really hope that you're not representing people as a non-attorney, but okay. I don't see a question there, so I hate to tell you, but there's nothing for me to say there. Sounds like someone that just wanted to get their point across and point taken. Michelle, good to know that finding meetings don't have to be noticed. They do have to be noticed, but only to the person that's being fined. And are other homeowners allowed to ask to attend? They can ask whatever they want, but they're not automatically entitled. Nicholas is just continuing his comments. Renee, my understanding is that you can't vote by email. Correct. So, question is, if the board makes a decision a day before the board meeting, can they then ratify the decision with a vote? Yes, that is commonly done, but I am not aware of any actual statute or case that allows for ratification. It's just commonly done. I've been looking for case law, and if anyone's on and has found it, I'd love to see it. But I've never seen anything that allows for ratification of every decision that a corporation makes. So I will advocate for it all day long, but I'm not aware of any specific law that actually authorizes it. Dominic, thank you for your kind comments. Nicholas, the better option is okay. Well, again, these are all comments. That the Q&A is question and answer, not comment and answer, but thank you. Monica, you mentioned that the date changed from July 1st to June 31st for CE hours. Did this recently change? It was January to December. It was never January to December. The statute was not adopted until July 1st, 2024. The DBPR actually started allowing the classes in July 1st, 2025. So it was never January to December. It was every year. Some people interpret that as January to December. So I'm not saying you're wrong. I'm just saying that what we've heard from DBPR and Jeff has expressed he got in writing from them is that it is from July through June that you have these 4 and 8 hour requirements that you're required to meet.
So, Alan, one of the things DVPR is required to do is promulgate rules, and they haven't done it in a very long time.
Correct.
They're in the process of doing it. I literally saw the rules for comment yesterday morning. So I think they took a step back to see what legislature was going to do this year. As we said, they really did nothing. So we might actually get new rules in 26.
I'd love to have a clear answer on that they are going to follow. Because it's funny, we just talked about this during our earlier today, our HOA board certification class. Jeff mentioned it, and I said, it's cute that you think they'll follow their own statements.
Depends who you talk to over there.
Right. And it's not against DBPR. I think they do a fantastic job of a lot of things. It's just the creation of rules. I mean, they were supposed to create these rules in July of 2025.
Yeah.
We're almost in July of 2026, and they're just now starting to put it together. So again, I understand they're underfunded, but it's very difficult for us to be able to guide our clients when the statute's not clear, DBPR is not creating rules, and the association's still going to get in trouble if they don't follow these unclear rules. So
100%.
Soapbox away. Angela asked for a website, book, etc., that explains what should or shouldn't be doing during a board meeting and what should go in the minutes. I mean, I'm fine with the updates and allowing questions, but understand you're going to make your minutes or your meeting very long. It should not make your minutes long because you're not voting on any of the reports that you're making. So it could be, hey, we made a report on XYZ issues. That would go into your meeting minutes if you wanted to, but it doesn't have to.
Yeah, we say minutes, not hours, right?
Correct. I like that. I'm sorry, but I'm going to have to steal that. I like it.
Good one.
All right.
Wasn't mine to begin with. It's all yours now.
That's a good dad joke, not a bad dad joke.
Yeah. Is the 3-minute rule applicable for each agenda item before a vote? Well, again, I can't say whether it's before a vote, but it's applicable to each agenda item. It is the max time for each comment by each member on each agenda item. And it has to be in a written policy in order for it to really be enforceable. But it's not, it's each agenda item, but I won't say before or after the vote because that is a board decision based on your policy. Leanne asks, can a board member attending a board meeting via phone or Zoom vote on items to be voted on at the meeting? Yes. Leanne asks again, also, is there a quorum of a board if a board member is attending via Zoom or phone? As long as they can be heard and seen, or if it's the phone, heard, the answer is yes. Dominic, knowing that everyone wants to protect their investment, but how is Freddie Mac and Fannie Mae controlling the sales for associations to a point of even how associations' reserve study time frame is dated? Well, the way they're controlling is they get to decide on most loans what's going to be required, and they just won't lend money if you don't meet their requirements. So they're not dictating what the association has to do, but if you want a loan that's backed by either one, You have to comply with their increasingly absurd requirements, is the way that I'll put it. If you're complying with Florida law, that should be enough. This is a government entity. They shouldn't be making business decisions. The government wastes, I won't get into politics, but the government wastes more than enough money where they shouldn't be dictating whether or not you can buy a home. And that's basically what they're doing. So I agree with the sentiment. I wish I had a better answer, but in reality, you just got to do your best. And once they come out with all of these new requirements every few months, you just got to figure out how to comply. Sean, if a board member doesn't have the yearly 4 hours of continuing education, but they're certified, are they also suspended? I mentioned earlier today during our board certification. I don't know. It says you're required to do it. Statute's clear on that front. I don't know that it's so clear, excuse me, so clear that you're suspended if you don't. So I hate to say it, but I don't know. I know no attorney is ever supposed to say I don't know, but I'm one of them that will if I really don't know. Leanne, can a board management meeting that includes copies of members who are delinquent be posted on an open public access website? I don't know what that means, but I'm going to try and interpret it to be that, yes, you can post that meeting, but not on an open public access website. You can post it for the members. They're entitled to know who's delinquent and who's not. They're entitled to copies of all ledgers if they request them as part of a records inspection. But the association should not be posting delinquency information in any forum that can be accessed by anyone who's not a member, period. I treat minutes as a history. I should probably stop. Angela, I could not agree more, and I'm glad you got something out of this class. Isaac, how can we remove a person that wasn't approved by the board and the owner of the unit, keeping them in the unit? That's a covenant enforcement issue that you, in reality, will need to review your covenants, see if you've got those leasing provisions or occupant provisions. That's something, honestly, I can't answer during a class like this, and you'll need to reach out to your association's counsel as to what your governing documents allow and don't allow. Leanna, revised question. Can the monthly management report presented for board view be posted on an open access public website? Same answer, no. Dominic, my info is that we're getting close to DBPR creating an actual affidavit for associations to be able to access when reporting to the agency. Thank you again. All right, thanks. Renata, if our HOA hires KBR, can we select you, Alan, as our board attorney? The answer, in short, is yes, and I appreciate that question. The only thing I can't promise is that I'll be the only one you work with. As I mentioned, we've got 27 attorneys. 3 are in my office now. 1 litigator is coming into my office next Monday starting. And, I can't promise you won't be working with other people, but I can promise you that if you sign with the firm through me, I'll be your primary attorney throughout the entire relationship. And that was a great one to end on. I'm going to go out on a high note there.
Good choice.
That is a great one. Well done. Great job. And I know it's end of the day, and you got to wrap things up, guys. But before you head out, first, Jason, as the host of our event today with Trident, we want to thank you. Anything you'd like to mention to everybody before you head out for the day?
No, thank you guys for putting this together. Alan, great job. It's a lot of
Thank you.
information and you killed getting through it. Fun time with the Q&A. I'll just reiterate, ask Alan any questions you need. Very happy with the work we've done with his firm for many years. And feel free to use me as a resource. I dropped my info in there and they all know how to find me too.
And Jason, thank you for having us. I mean, this was a great program. This is the first time I've taught this class, but in reality, it's part of the board cert, so it got a little easier for me since I already taught it today. But I truly appreciate the invite and happy to participate in other education programs you guys want to put on anytime.
Awesome. Looking forward to it.
All right, thanks everyone for attending. Jeff, I'm technically already late for another meeting, so I'm going to jump off.
Ciao for now.
Thank you, guys.
Take care. And Jason, you as well. Thank you, sir. You're welcome to hang out. I usually remain on and I have the chat open. If anybody's having any technical difficulties with the evaluation or any other questions or concerns about getting your certificates, I'll stay on for about 5 more minutes to answer your non-attorney related questions in the chat. Even if I know the answer, Jason and I cannot pretend to be attorneys, right? So
not today.
Not today. Only on TV.
Yeah.
But good to see you, man, and hope
You
to see you
too.
in
Take
person one
care
of these days.
and happy to talk to you. Happy to have you around. Thanks.
You as well. See you soon.